prepared a copy for your worship as well as for the state, and with your permission I would request your leave to read the affidavit of the applicant into the court.
Thank you, sir. You may do that.
Spot, please, Your Worship. This is the affidavit of Nandipha Magudumana, and it reads as follows: in the magistrate court for the district of Mangaung, held at Bloemfontein, in case number 28/113 of 2023, in the matter between Nandipha Magudumana, the applicant, and the state, the respondent, affidavit in support of bail application. I, the undersigned Nandipha Magudumana, do hereby make oath and state as follows. Paragraph 1. I am an accused and an applicant in this bail application which seeks relief from this honorable court to be released on bail. I am an adult female aged 34 years of age. Paragraph 2. I respectfully submit that I will demonstrate herein that it is in the interest of justice that I be released on bail. Paragraph 3. In an event, the dictates of fairness and justice in view of the peculiar facts herein warrant that I should not be deprived of my liberty and that I should be released on bail. Paragraph 4. I make this affidavit out of my free will and will not in any way be unduly influenced to impose hereto. Paragraph 5. The facts contained herein are within my personal knowledge unless the contrary appears from the context, and are both true and correct. Where I make legal submissions, I do so on the basis of advice provided by legal representatives. Paragraph 6. Purpose for application. 6.1. The purpose of this affidavit is to provide the Honorable Court with my personal circumstances and to address the factors to be considered by the Honorable Court as contained in Section 60 subsection 4 to Section 60 subsection 9 of Act 51 of 1977. 6.2. I have been advised by my legal representatives that my bail application will result under Schedule 5 of the Criminal Procedure Act 51 of 1977 due to some of the charges preferred against me. 6.3. I have furthermore been advised and fully aligned to such advice that I bear the burden to show that the interest of justice permits my release and that I am obliged to initiate this application. Paragraph 7. Personal circumstances. 7.1. I am a South African citizen by birth. I was born in Port Edward, KwaZulu-Natal province on the 4th of September 1988. My South African ID number is 880904054184. 7.1.2. I attended Port Shepstone High School where I matriculated. 7.1.3. Prior to my arrest in Tanzania, I resided for a period of approximately 2 years at number 22A Second Road, Hyde Park, Sandton, Gauteng Province. 7.1.4. I previously stayed for a period of 10 years at house number 35B, Townsend, Bedford View, being my marital home until I separated with my husband for reasons which I will divulge for purposes. I will not divulge for purposes of this bail application. My apologies, Your Worship. I should have written I will not advise. I will not divulge. I intend staying with a friend at number 7, Aragon Estate 158 Helen Road, Sundown Extension 56, Sandton, Johannesburg, Gauteng Province. The Honorable Court is referred to a copy of an affidavit from my friend confirming same marked as Annexure FA1. I do not have relatives that I know of outside the Republic of South Africa, and I do not possess any assets outside the Republic of South Africa. 7.7. I have permanently resided in the Republic of South Africa my entire life. 7.1.8. I have no intention to relocate to any other country. The travel documents. 7.2. I have one South African passport which was confiscated during my arrest in Tanzania. I thus currently do not have any travel document in my possession. 7.3. Family background. Both my parents are still alive and they permanently reside at 632 5th Street, Port Edward. I have 3 siblings. I'm currently married but separated with my husband. I have two minor children, girls aged 11 and 6 years respectively. My 11-year-old is at grade 5, while 6-year-old is at grade 1. I have full parental responsibility and rights of my two minor children in terms of Section 18 of the Children's Act 38 of 2005. I have specific parental responsibilities and rights with regard to primary care, including primary residence of my two minor children as contemplated in Section 18(2)(a) of the Children's Act 38 of 2005. Tertiary education and work history. I possess the following tertiary education: BSc in Health Sciences as well as an BCHB from University of Witwatersrand. I'm a medical practitioner and a founder of Optimum Medical Aesthetics, a skincare and aesthetic clinic in Sandton. I was, until my arrest, still practicing at the said clinic. I earn approximately 50,000 rand per month. 7.5 assets. I own various movable properties, including furniture and household possessions, as well as my medical practice equipment, cumulatively to the approximate value of R1 million. I do not own any fixed assets. Criminal history. 7.6. I have no previous convictions and there are no pending criminal cases against me. I also declare that I have no knowledge of any outstanding warrants of arrest against me. I further declare that I do not have any order against me as contemplated in Section 5 and 6 of Domestic Violence Act of 1998, nor do I have an order against me as contemplated in Section 3 and Section 9 of the Protection from Harassment Act of 2011 or any similar order in terms of any other law. Paragraph 8. Circumstances around my departure from South Africa. I have been advised that I have the right to remain silent and not reveal the basis of my defense, and that I should reveal the basis of, and that should I reveal the basis of my defense, it may be used against me at the ensuing trial. Albeit I have decided to exercise and assert my right to remain silent and not to disclose the basis of my defense until at the appropriate time and forum, I nevertheless wish to provide the following context to how I departed South Africa. 8.1. On or about the 17th of March 2023, I was in company of accused number 5. 8.2. I was instructed and commanded by accused number 5 to get into a vehicle and leave the premises to a destination unknown to me at the time. 8.3. I refused and wanted an explanation, but he forced me into a vehicle. 8.4. I succumbed to the pressure due to the threats he directed at me. 8.5. I was defenseless, helpless, and with no one to report to at that time. 8.6. I complied with his instructions and was taken out of the country against my will. It should read 8.7. At all material times, I had no control over the situation because I was scared of the threats made by accused number 5. 8.8. I submit that I did not voluntarily depart from the Republic of South Africa as demonstrated above. And 8.9. In any event, I had no reason to leave the Republic of South Africa. Paragraph 9. The salient factual background on my arrest. 9.1. On the day of my arrest in Tanzania, I was apprehended by members of the South African Police Services who called me by my name and were communicating in isiZulu language. I was then taken into custody in an unknown facility. 9.2. Upon my arrest, the said members of SAPS discovered passports inside the cubby hole. I was later informed that one of the passports belonged to me. At all material times, I was not aware that my passport was in the vehicle. 9.3. I remained in custody in Tanzania, where I enlisted the services of one advocate, Sambo, to provide legal service. 9.4. I was, however, taken to South Africa through methods which are currently being legally challenged. 9.5. I have been in custody at Mahate Correctional Facility since 13 April 2023 to date. 9.6. As indicated, I have challenged the legalities of my apprehension and arrest in Tanzania by officials of South African Police Services and the Department of Home Affairs, as well as my subsequent unlawful return to the Republic of South Africa. 9.7, albeit the application was unsuccessful, I have launched an application for leave to appeal at the Supreme Court of Appeal. 9.8, I initially reserved my right to launch bail application at an appropriate time. The said approach was informed by my fierce challenge of the illegal abduction and subsequent extradition disguised as deportation, by which the High Court confirmed to be so. Paragraph 10, the charges. 10.1, I have been informed that I am being charged with the following. 10.1, aiding, escape, concealing and harboring. 10.1.2, 2 counts of violating a body. And 10.1.3, 2 counts of fraud. It should read 2 counts of fraud and not fraud counts meaning. 10.2, I intend pleading not guilty to the charges referred against me by the state. 10.3, I have been advised that I have the right to remain silent and not reveal the basis of my defense. But should I reveal the basis of my defense, it may be used against me at the ensuing trial. I have decided to exercise and assert my rights to remain silent and not to disclose the basis of my defense until at the appropriate time and forward. Legal submissions, paragraph 11, 11.1. In order to persuade the above honorable court that I should be released on bail, I provide the following additional facts and information in terms of section 60 of the Act 51 of 1977. Paragraph 60, sub 4a, being danger to public or individual safety. 11.2.1, I respectfully submit that there is no likelihood that my release on bail will endanger the public safety or that of any particular individual. 11.2.3, I have no history of violent behavior, nor do I have any predisposition to commit offences referred to in Schedule 1 of the Criminal Procedure Act 51 of 1977. 11.2.4, I will also not commit any offences against any person in a domestic relationship as defined in Section 1 and 5 of the Domestic Violence Act of 1998, or any offence referred to in the Protection from Harassment Act of 2011. Section 60, subsection 4b, evasion of trial. I respectfully submit that there is no likelihood that I will attempt to evade my trial. 11.3.2, my arrest in Tanzania is currently a subject of litigation in the Supreme Court of Appeal. I, however, wish to highlight that my deportation to South Africa was declared by the Free State High Court to be a disguised extradition and thus unlawful. I do not intend to belabor the point any further for reasons alluded in observance of sub judice. 11.3.3, I submit that this is evident from my conduct since the inception of the investigation. I have not supplied any false information, nor have I supplied any false information for the purpose of this application. I undertake to attend court faithfully on each and every occasion to which this case might be postponed to. I have no intention to live the life of a fugitive. 11.3.4, I submit that the likelihood of absconding trial has to be evaluated in terms of Section 6, subsection 9 of the CPA, balancing the interest of justice with my right to personal liberty. 11.3.5, I will stand by my trial should it proceed against me. I am a well-known medical practitioner and there is no possibility that I will even think of not standing my trial. 11.3.6, I submit that any objections to my release on bail could be accommodated by bail conditions. Section 6, subsection 12 of the CPA provides possibility of imposing alternative bail conditions that can be used to minimize the risk if there is of absconding. 11.3.7, such conditions include inter alia, being required to report the police station at regular interval as the case may require. This I submit shall ensure that I can be located. 11.3.8 finally, submit that the use of bail conditions as delineated above is a clear way to ameliorate the competing interest of risk of absconding with fairness to the bail applicant. Paragraph 11.4, section 60 subsection 4c, read with section 60 subsection 7 of the CPA. I confirm that a list of state witnesses has been furnished by the state to my legal representatives. I, however, wish to categorically state that I do not know the identity of any witness upon whom the state will rely in order to attempt to prove a case against me. In any event, I have no intention to interfere with any witnesses, as I have no cause to do so, and I undertake not to do so. There has not been any allegation that I have attempted to influence or intimidate witnesses. I therefore respectfully submit that there is no likelihood that this subsection is at risk to be infringed upon should I be admitted to bail. As previously stated, I have no previous convictions and I have not been released on bail pending any charges. I am, however, willing to comply with reasonable conditions of bail in this regard should the Honorable Court deem it appropriate to impose such conditions. 11.5, section 60, subsection 4d, jeopardy to the functioning of criminal justice system or bail system. I submit respectfully that there is no likelihood that this subsection is potentially to be infringed upon should I be released on bail. I have not furnished any false information to the investigating officer, nor have I furnished false information for purposes of this bail application. Section 60, subsection 4e, exceptional circumstances in brackets, presence or absence, which may lead to undermining public order or peace. I was advised by my attorney, which advice I accept, that this factor is not applicable to my application. All co-accused in this matter, with the exception of 2 accused, have been admitted to bail. There has not been any public disorder as a result thereto. I will be able to raise an appropriate amount proposed as bail in the amount of 10,000. Relief sought, paragraph 12. In the premises, and taking into consideration the relevant schedule the charges result under, I respectfully submit that I have, on the preponderance of probabilities, proved the existence of interest of justice that may be granted to me in an appropriate, affordable amount of 10,000 rand, and with such conditions attached as the court may deem fit. The affidavit has been duly signed by the applicant Nandipha Magudumana and also commissioned by the Commissioner of Oath